welcome to all. May I request the participant to put their mobile phone on silent or in switch off their mobile phones for better. May I call upon the dignitaries to ascend to the stage. May I call upon Hon'ble Mr.Justice.N.Anand Venkatesh. May I now call upon our President, Mr. M. Bhaskar, to ascend to the stage. May I call upon Mr. N.R. Ilango to ascend to the stage. And Mr. Thiruvengadam, Secretary, to the stage. To start the program, it starts with Tamil Thai Valthu. May I request Mrs. Shanti Meenakshi and Mrs. Tulasi to sing the Tamil Thai Valthu. And the group.
நீராரும் கடலொடுத்த நிலமடந்தை கெழிலொழுகும் சீராரும் வதனமென திகழ்பரத கண்டமிதில் தக்கணமும் அதிர்ச்சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிலமை திறமையந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
This should be the second lecture of MBA with Rakesh Law Foundation. The first lecture was also given by Hon'ble Mr.Justice.N.Anand Venkatesh. And I may now request Mr. M. Bhaskar to give the welcome address.
Good evening, everybody. I welcome Honorable Justice Anand Venkatesh, Honorable Justice Saktivel, our MP N.R. Ilango, Additional Solicitor General A.R. Sundaresan, other dignitaries. Today, the MBA Madras Bar Association, the MBA Academy in coordination with the Rakesh Law Foundation, we got a lecture on the topic, a judge criticizing his own judgment in the matter of suit for land, by Honorable Justice Mr. Anand Venkatesh, Judge High Court Madras. In fact, this invitation was given to Honorable Judges and one or two judges. Why? Oru mala neelathukku and topic irukka. Now, about the Rakesh Law Foundation. This Rakesh Law Foundation was created on 16/4/2021 by a trust, and our MP N.R. Ilango is the author of the trust, Aruna Ilango as the chairman, Raghavi Ilango vice chairman, and other trustees. The object of the trust was created with an object to educate and empower law students and further to engage law students and young advocates intellectually what would benefit the society to greater extent. And there are good deeds which have been done by the trust so far. They have adopted a school, the Greater Chennai Corporation Higher Secondary School, Amijakarai. They have provided RO water systems, appointed teachers for special coaching, G and NEET exams, improved infrastructures including library and laboratories, provided hygiene products, books and sports equipments. Every year in the month of April lectures, they are conducting lectures by eminent jurists. Opened a library section in the Madurai High Court. Then they are constantly working towards the welfare of the students. Now, about the speaker today. I happen to be lucky to attend a function organized by none else than Sriram Panju, senior advocate, in the Sai Foundation, Sai University, I believe, subject correction. The lecture was on the Chief Justice John Marshall, who served as the 4th Chief Justice of United States from 1801 until his death in 1835. Why I am saying is this: he was a Chief Justice, but he was never a judge. He was directly elevated as Chief Justice. In that meeting, Sriram Panju, a pioneer in mediation, called our speaker as Lord Denning. And also he remarked that, and on one matter, I don't want to say about that matter, our Chief Justice Chandrasud said, "Thank God we have got judges like him." With these few words, I welcome all the dignitaries of and others. Thank you.
May I request Mr. N.R. Elango, Senior Advocate, to give the introduction speech.
Hon'ble Justice Mr.N.Anand Venkatesh, the President of MBA, Secretary of MBA, Hon'ble Justice Mr. Saktivel, Senior Advocate Mr. Sriram Panju, my dear elder brother Mr. A.R.L. Sundareshan, seniors, ladies, gentlemen, friends. First of all, I thank the members of MBA for accepting the proposal of Rakesh Law Foundation to conduct this lecture series on the occasion of birthday of my son Rakesh. It is actually on 16th April, but this year, because of elections, we have decided to conduct it today. The President of our Bar Association is gracious enough to speak about the foundation. Apart from that, the Rakesh Law Foundation is also organizing to conduct moot courts in VIT Law College, because it is the college where he studied. I thank the Honorable High Court and its the committee which gave permission to conduct this lecture in this library hall. The invitation mentions about saying that I have to give introduction speech. I don't know what introduction I have to give, because the President has spoken about the trust. He has introduced the trust. The speaker doesn't require any introduction. So I have to only introduce the topic. A judge criticizing his own judgment. Friends, it's whenever I walk in the corridors of this High Court, I always feel that I'm in the lap of my mother. What I am today, whatever I have today, is only because of this institution. I feel it's my duty to give back to this institution something. And through Rakesh Law Foundation, I'm trying to organize lectures, help students and all that. Whether lectures like this will help the young mind, certainly it will help. Because studying law or reading law is alone not enough. You have to think about what you are going to argue. You have to develop the skill of having an original thinking. to have original thinking, these lectures will help you a lot, number one. Number two, as lawyers, or not only lawyers, as a human being, all of us have to have necessarily a self-introspection every time, every day, every year. Self-introspection is required for every man, every lawyer, every judge, every institution. But this kind of introspection, to have this kind of introspection, you must have courage. Justice Anand Venkatesh is one among the few who is having that courage. Now he is going to say why something is wrong with his judgment. I request the lawyers, the young lawyers, to take that from him, learn how to introspect yourself. After every argument, after reading every case, you must introspect yourself, whether I did justice to the case or not. That's why these lectures will definitely help you. Rakesh Law Foundation is very happy to have him here. And I once again thank the members of the Madras Bar Association to accommodate Rakesh Law Foundation to give this, arrange these lectures. With this, I conclude my speech. Thank you very much.
Now the felicitation. I request a former Advocate General Mr. Navanand Venkatesh to put a shawl to the Honorable Judge. Now I request A.R. Sundaresan, Additional Solicitor General of India, to give a memento to the Honorable Judge. Now I request Mr. Neelangandan, Additional Advocate General, to put a shawl to our Member of Parliament, Mr. Elangalangu. May I request our Senior Counsel, Mr. Sriram Panju, to give a memento to the Member of Parliament. Thank you.
May I now request Hon'ble Mr. Justice.N.Anand Venkatesh to deliver the presidential address.
I'm quite stunned with the crowd that has assembled here on a Friday evening. Rakesh must be seeing it from somewhere and he must really feel so happy about this. And this crowd is for Rakesh and not for me. That's how I take it. When Mr. N.R. Ilango, senior advocate, mooted this idea of having a series of lectures, I volunteered and promised him that I will give a lecture every year till people push me away and say, stop it. So I promised him, and this is the second lecture I am giving. So thank you so much for N.R. Ilango for again and again, trying to inculcate this habit of continuous learning of law. That's very important for an advocate. Whatever position he holds, at the end of the day, each one of us is a student of law. So we must keep on doing this, and this is one source from which it has emanated. Every time when it emanates from N.R. Ilango, there is some general presumption that it has to be only on the criminal side. So I thought I'll break it. Why should it be every time on the criminal side just because N.R. Ilango his specialization is in that area? So I broke it and I said that this time it is going to be civil. It's very special for me also because the case about which I am going to talk now was actually argued by Mr. Sriram Panchu, senior advocate. Of course, I held it against him. So therefore, I forwarded this invitation to him, and I told him that this is what I am going to talk about, and it will be a sort of it's not an apology, but it's going to be a sort of explanation to him as to why he was right in that particular case. I was elevated on June 4th, 2018. So I was just a toddler. I was a baby in the bench. But the man who was sitting next to me, Hon'ble Justice M.M. Sundaresh, now the judge of the Supreme Court, on the very first day he said that you are going to run a marathon right from day one. So whatever case comes up, he will just look at me, I will say, I will pass the orders, I will pass the judgment. So it was a great encouragement to sit with a judge like him when you start your career as a judge. So I feel that I was so lucky to sit with him, and that's the time when this judgment was delivered by me in Harsha Estates versus Kalyana Chakravarti. This judgment was delivered on 23rd of July 2018. So hardly it was a month or so, more than a month. So that over enthusiasm was there. Before getting into that, since many juniors have also come here, I would want to lay down some fundamentals so that you will understand the perspective and where I am going from here. See, from the earliest times, the remedy of specific performance is grounded on two fundamental principles. Till today, it prevails. The first one is that it is always a discretionary remedy. And Section 20 of the Specific Relief Act is a statutory equivalent recognizing this principle, that it's a discretionary remedy. And the second principle is that this relief always operates in personam. There is something called as in rem and in personam. Since I don't want to give an explanation on all that, considering the crowd before me. So the relief always operates in personam, irrespective of where the property is situated. These fundamental things must be kept in mind before proceeding further with what I want to say before this August gathering. This position of law was clarified as early as in 1893. if the juniors want to note down the judgment, please note down the judgment so that you will have the advantage of reading it. This judgment is British South Africa Company versus Companhia, Companhia, 1893 AC page 602. In this judgment, I said that this is the principle of law that has been prevailing right from the beginning. And in this judgment it says, while courts of equity have never claimed to act directly upon the land situated abroad, they have purported to act upon the conscience of persons living here. So those were the wordings of the House of Lords at that point of time. And this was a further clarification to whatever was the law which was in existence at that period. In India, the 1963 Act, as you all must be knowing, is nothing but a statutory expression of these equitable principles. As I told you, the remedy of specific performance is an action in personam, and this position has been reiterated till the latest judgment of the Supreme Court. If you want, you can note down. Santoshamma versus Sarla, 2020, 19 SEC, page 80. Since many juniors are here, I thought I can give the citations to you so that you will have the advantage of going and reading it. Seniors, it is your discretion. Now, let me go into clause 12 first. As you know, this is a chartered high court. There are 3 chartered high courts in India, one in Madras, other in Bombay, other in Calcutta. We were given this charter, the letters patent governs us, and clause 12 of the letters patent deals with 3 categories of suits. The first category is suits for land or other immovable property. That's category 1. Category 2 is suits based on cause of action, either wholly or partly. And category 3 is suits based on the situs of the defendant residing or carrying on business within the territorial limits of the High Court. So basically, these are the 3 categories of suits which falls within clause 12 of the letters patent. That's what governs it. So the question is whether the suit for specific performance is a suit for land within the meaning of clause 12. This is going to be the basis of what I am going to proceed further from here. As I told you, I sat in a bench with Hon'ble Justice M.M. Sundaresh, as he then was, and I authored that judgment. With all confidence, Justice M.M. Sundaresh also said, I agree. So after this, I will have to go and tell him that I criticize this. So this is Harsha Estates versus Kalyana Chakravarti. This judgment was reported in 2018, 3 Law Weekly, page 900. Page 900. So in this judgment, an elaborate analysis was made as to what this suit for land is and how do you understand it qua clause 12 of the letters patent. While doing so, after taking into consideration many earlier judgments, at paragraph number 10, the principles of law were elucidated at paragraph number 10. And in that, what is important is to note down where I consider it as a is something which has to be corrected. Apart from elucidating the other things, like saying that one, it will be in a suit, the relief claimed if granted would directly affect the title to or possession of the land, it will be a suit for land. Then secondly, if the object of the suit is something different, but involves the consideration of a question of title to a land indirectly, it will also be a suit for land. All this is settled. Then the suit where the claim is for recovery of possession or control over the land, obviously it will be a suit for land. Then fourth is in a suit for where determination of any right or interest over an immovable property is involved, then it will also be a suit for land. In a suit for bare injunction restraining the defendant from interfering with the possession and enjoyment of the property by the plaintiff per se it will be a suit for land. The question is, how do you look at all these things when it relates to a suit for specific performance? That's the sum and substance of what I am going to address. The first mistake, if I may say so, is this principle which was enunciated where it was held that in a suit for specific performance, where the suit is only for enforcement of the agreement simpliciter, without seeking for any other relief, the same will also fall within the ambit of suit for land, since the relief of possession is inherent in the relief of specific performance. So I had in my mind, as you all must be knowing, Order 21, Rule 32, Clause 5. So it's a consequence of a suit for specific performance. So I said that even if you, we said, even if you file a suit for specific performance simpliciter without seeking for any other relief, since the ultimate relief which you will be getting is the possession over the property if you succeed in the suit, it was held that it is inherent and therefore it will also be considered as a suit for land. This is one thing which according to me requires some reconsideration. The next thing is, in a suit for specific performance where the plaintiff, apart from seeking to enforce the agreement, also seeks a relief of injunction against the defendant, not to interfere with the possession and enjoyment, or not to create any charge or encumbrance, or not to alienate the suit property, such suits also will come within the ambit of suit for land. So these are the two principles which were enunciated in the judgment, which in my very respectful submission would require reconsideration. So the first is suit for specific performance simpliciter without seeking for any other relief, which ultimately will result in possession because it is inherent in that suit, which was held also to be a suit for land. Second is, main relief is for a specific performance and consequential relief is for a permanent injunction restraining the person from alienating, from etc. etc. So not to create a charge, not to create an encumbrance. It was held that that will also fall within the ambit of a suit for land. So these are the two debatable principles which were enunciated in that judgment, about which I am going to address before you. So NAV is addressing something against this judge called as NAVJ. And NAV is saying that those findings, those principles that were enunciated by NAVJ may not be right and it requires reconsideration. This attitude, my friends, is very important, because at the end of the day, evolution happens not by merely learning. Evolution happens even by unlearning. Evolution happens when you know that you have committed a mistake and you are willing to correct your mistakes. An institution is involved here. There is nothing personal in this. Everybody is bound to commit a mistake, and once you know that a mistake has been committed, it's very, very important that you immediately recognize the fact that you have committed a mistake and try to change it. So that's the purport of this talk. I realized that there is a need to reconsider it. And you will ask, how did you get that sudden realization? That's the next question, the natural question. First was when I read the detailed article that was written by Parthasarathi, senior advocate. S. Parthasarathi, correct? Satish Parasaran's office. R. Parthasarathi wrote a thesis virtually. It was a scholarly article. It was a huge article. They had to publish it in 2 volumes, meaning it was not able to be completed in one part. So it went on for 2 parts. And I consider that to be one of the most scholarly article written about what is the suit for land is all about. So that is one article which really made me think as to whether these things which I said in that judgment is right or not. And the second is my very detailed discussion with Mr. Sharath Chandran. He is one of the young shining stars of this court. who is so good in all areas of law. So he said that I want your permission to criticize your judgment. I said you don't need a permission at all, because the moment I sign, it is not my judgment, it's the judgment of this court. Then he said, why certain principles that have been elucidated in that may require reconsideration. I had a very detailed discussion with him, and that is yet another instance where I thought that these two things which I said in that judgment may require reconsideration. So the reason for, or the spark came from the article of Parthasarathi and my discussion with Sharat Chandran, and I think it is my duty to tell you as to what really inspired me to do this. So therefore, I am telling their names here. So first of all, we will have to see how the law evolved and where the mistake actually crept in. It's very important because some stage some mistake crept in. So before going into that, you should know where the law actually evolved. The first judgment is the judgment of the full bench of our court, as always, in Vellayappa Chettiar versus Shah Govind Das. That judgment is reported in AIR 1929 Madras, page 721. See, that was a suit for specific performance relating to a land situated in Chittoor. That's very important. It was a land situated in Chittoor. It is presently in Andhra Pradesh. This was exactly the question that was dealt with by the full bench, and it was a unanimous judgment. In that judgment they say, 1, it is a suit in personam where the decree is addressed to the defendant resident within the territorial jurisdiction of the original side of the High Court. This is the first principle they said. Then second, it does not involve adjudicating title for land. That's the second principle. And the third one was the question of possession. This is the most important observation which many missed actually. The question of possession is also not directly in issue in such a suit, is what they said. So this 1929 judgment came up with these principles. This judgment went on appeal before the federal court. Before the federal court, actually this judgment did not go before the federal court. One judgment of the Bombay High Court. As I said that we are governed by the letters patent, I said there are 3 courts, chartered courts. So one division bench judgment from the Bombay High Court went before the federal court on appeal, and this issue was also considered. That judgment is the famous Moolji Jaita judgment. Moolji Jaita Company versus Kandesh Spinning and Weaving Mills, 1950 SEC Online FC, Federal Court, page 3. 1950 SEC Online, Federal Court, page 3. This was a 3:2 judgment. This was a fractured judgment, if I may say. The effect of this fractured judgment, this 3:2 judgment, was thereafter considered by the division bench of Calcutta in Debendranath Chowdhury versus Southern Bank Limited. This judgment is reported in AIR 1960 Calcutta, page 626, authored by one of the best minds in this country, Justice Mukherjee, who was then the Chief Justice. Till this judgment which I was talking, the position was quite clear. The position was a suit for specific performance, irrespective of the question of the ultimate possession being given or obtained, was not a suit for land, and such relief was only ancillary to the main relief of specific performance. This was exactly the law on the issue by the full bench, later by the federal court 3:2, and this was the law that was prevailing. The next question is, the most important question according to me is, will the prayer for possession or the ultimate result of possession will alter the character of the suit for specific performance. This is where the confusion starts. If it is just a suit for specific performance, there will be no confusion. If there is a prayer for possession, or you know that ultimately this decree is going to end up in possession, will that alter the character of the suit? That is the moot question. This was dealt with by a division bench of this court in Sundara Ramanujam Naidu versus Sivalingam Pillai. This is AAR 1924 Madras 360. They also came to the very same conclusion which I told you now. This was subsequently followed by Justice Ismail. Justice Ismail followed it in Raja Badar versus Saeed. This judgment is AAR 1974 Madras, page 289. Please keep this in mind that these two judgments which I quoted now, one is this Sundara Ramanujam Naidu judgment 1924 Madras, and the judgment of Justice Ismail in Raja Badar's case in AAR 1974 Madras have been cited and it has been approved by the Supreme Court in a very recent judgment in Manikam versus Vasanta. That is reported in 2022 SEC Online SC page 2096. This position has been affirmed by the Supreme Court in the latest judgment. So the next thing is, can other reliefs be also sought for in a suit for specific performance? Your natural question will be that. Section 22, as you all know, has come into the Act, and Section 22 enables to claim for partition, it enables you to claim for possession, it enables you to claim for recovery of money, etc. And this was introduced by the Law Commission in its 9th report in the year 1958. The scope of this Section 22, the confusion is because of this 22 only. That's why I am focusing on 22. The scope of this Section 22 was considered again by the Supreme Court in Babulal versus Hazarilal Kishori. That judgment is 1982 1 SEC page 525. 1982 1 SEC page 525. And also yet another judgment which I quoted earlier, Manikam versus Vasanta. There also they have considered this judgment. There they said that in a suit for specific performance, specific prayer for possession will be required only when A, there is a third party transferee. Please keep in mind, I am not talking about a pendentilite transferee. Pendentilite transferee per se does not have any such protection. Even the protection under 19 on bona fide purchaser will not apply to a pendentilite purchaser. So one is, there is a third party transferee. B, where the property is jointly held by defendants and by the defendant who executed the agreement of sale and others, and then in such a case, since only that portion of the property the agreement of sale has been entered into, you will have to necessarily seek for possession, because the entire property has not been given to you under the sale agreement. So in such circumstances, the second occasion is, you will have to seek for possession where the property is jointly held by the defendant and also others. Then you will have to seek for partition and separate possession. Then it was also held that Section 22 is directory in nature, it is not mandatory. This is a very, very important position of law which many of us get confused. And this position has been confirmed, as I told you, in Manikam case in 2022. They specifically say that Section 22 is directory in nature. 22.2 is directory in nature. Now, all this is fine. Where did this confusion start? Where did the confusion actually begin? I thought it began with Atcon Electronics Private Limited case. Atcon Electronic Private Limited versus Daulat is a judgment in 2001 7 SEC page 698. See, in this judgment, the specific performance suit was filed in Bombay High Court, but the lands were situated in Indore. It was not situated in Bombay, it was situated in Indore. In this judgment, the Supreme Court concluded as, one, specific performance of an agreement alone claimed cannot be treated as a suit for land. Cannot be treated as a suit for land. The next observation made by the Supreme Court was the cause for all confusions which happened thereafter. This observation was, the Supreme Court said, considering section 22(2) of the Specific Relief Act, no court can grant relief of possession of land covered under the agreement unless it is specifically claimed. So Supreme Court in that judgment said it was an observation, because in that case, if you read that judgment, that relief was not even sought for. I don't know why that observation was made in that judgment, because that was a case where it was a suit for specific performance simpliciter. But this observation was made. Supreme Court said it is not enough for you to just seek for the relief of specific performance. You must also seek for the relief of possession, is what they said. So, as if you had carefully noted, now there are 3 judgments of co-equal benches. One is Babulal, second is Atcon, the next one I said Vasanti, 2022. All 2-member judgments. So how do you reconcile is the next question. It has to be reconciled. If you had heard Mr. A.R.L. Sundaresan some time back, when he spoke about the law of precedent, I think that was one of the wonderful lectures I heard. And he was talking about this specifically. What happens if co-equal benches are available, and which judgment will you apply in a case? I am sure Justice R. Subramaniam also had an occasion to deal with such a case. The important judgment is the latest one which I want to cite. It is better to have the latest one, which is Co-Magurus case, 2024 2 SCC, page 18. 2024 2 SCC, page 86. I want to specifically read what the Supreme Court is saying. A decision taking divergent views are rendered by benches of co-equal strength. The next course to be adopted is to attempt to reconcile the views that appear to be divergent and to explain those contrary decisions by assuming to the extent possible that they applied to different facts. This is important. The other course available is to look at whether the previous decision has been noticed, considered and explained in the subsequent decision. If not, the earlier decision continues to remain binding. Whereas if the answer is in the affirmative, the subsequent decision becomes binding decision. So when you are balancing, you will find that this observation made by the Supreme Court in the Adcon judgment never really went into the law that was explained in Babulal judgment. So in my respectful view, the law as was enunciated in Babulal and which was subsequently confirmed in Vasanti case in 2022 holds the field. It holds the field even now. How did the confusion start in Madras High Court? So I was also one of the victims of that confusion. So I'll have to say how the confusion started here. It started from the judgment of Justice M. Srinivasan. In Ram Bahadur Thakur case, 1989, 2 Law Weekly, page 529. So here I must say something. 1993 I was enrolled. In 1995, Justice Srinivasan had rendered a judgment. The issue was on the excess advance amount that remains in the hands of the landlord, whether it has to be automatically adjusted towards the arrears of rent or a request must be made. Hon'ble Justice Srinivasan, as he then was, rendered a judgment. I wrote a criticism on that judgment, 1995. So I handed it over to Mr. Gopal Ratnam. So he said, I'll read it and come back tomorrow. So next day he caught me near this juice shop. Enda, 93 la enroll aayirukka, 95 la nee Justice Srinivasan judgment criticize pannuviyo? Sir, I thought you have a long way to go. Forget about it nu solli poittaru. So Today, I have an opportunity to give my views on the judgment of Justice M. Srinivasan, which I am going to, which I am not agreeing. So today, Mr. Gopal Ratnam is not here, so I can freely talk about this. Not here. See, this judgment in Ram Bahadur Thakur, that was a suit for specific performance. And what happens is that there was a lispendence purchaser. As if you had carefully noticed what I said, when there is a third party purchaser, it will not include a lispendence purchaser. If the purchase had happened prior to the institution of the suit, then necessarily he must be made as a party because the possession has to be taken from him. Insofar as the lispendence purchaser is concerned, he will be bound by whatever judgments comes out of the case. Here, the fourth defendant is a lispendence purchaser, and therefore, possession was also sought for as against the fourth defendant. So this is the fact. Initially, as you know, you seek for the leave of the court because the property is outside, or leave is granted, revocation of leave comes up before Justice M. Srinivasan. And the Justice M. Srinivasan in this judgment holds that this is what he says. He takes into consideration this Mulji Jaita. I said that's the federal court judgment. It is seen that all the judges who constituted the bench in the federal court are unanimous on this aspect of the matter, that if a relief is sought in the suit for recovery of possession, then it will be a suit for land. In the present case, this is important. In the second case, the second prayer is for recovery of possession. That is sufficient to hold that this is a suit for land. Keep in mind that this subsequent prayer arises out of a transaction which took place as a lispendence purchaser. Since the prayer, the second prayer after the relief of specific performance was sought for, second prayer was for possession. He says, since you have asked for that, I will rely upon Mulji and say that it's a suit for land. I read to you the judgment, the ratio in that judgment in Mulji, where they say that it will not apply. If you remember the judgment in Mulji, I said that, yes, I said the question of possession, if it involves, if it's ancillary, if it's not directly involved in a case, they said that it will not be a question to consider as to whether it is a suit for land or not. This is the judgment in Mulji, but Justice Srinivasan J picks up from there and he says that the second prayer is for a suit for possession, is for relief of possession, therefore it is a suit for land, is what he holds. Then this judgment of Justice Srinivasan as a single judge is also contrary to the one more judgment which I said, that is Sundaram Naidu versus Sivalingam Pillai. This I said it's AR 1924 Madras. That's also a division bench judgment. That was not taken into consideration. And please keep in mind that there is a distinction between a suit for recovery of possession and a prayer for recovery of possession. There is a big distinction between both of these things. The prayer for possession in a suit for specific performance does not alter the character of the suit into one of recovery of possession. If it is per se a suit for recovery of possession, there is no problem at all. It directly becomes a suit for land. But the distinction is between what you are seeking for. And the next thing which the federal court said was that for a suit to fall within the net of the expression suit for land, the primary or direct object has to be considered and not the ancillary or the indirect object. So In fact, I would quote Justice Kanaya, who is one of the judges there. He said, the object cannot be that any question which indirectly or incidentally has any reference to land should be excluded from trial merely because the suit has some reference to land. In the ordinary way, therefore, a suit for land is one, the primary or direct object of which is to obtain possession of or an adjudication of title to the land. That is the test which was missed by Justice M. Srinivasan, and the attention of Justice M. Srinivasan was drawn to the judgment of Justice Ismail. In Raja Badar case, I said, and Justice Srinivasan says that he has his own doubts about the correctness of that judgment. He just shuns it, saying that I have my own doubts about that judgment. That's the only thing which he says. Then he also holds that section 22(2) is mandatory. I already told you that 22(2) of the Specific Relief Act is directory in nature, and that's the latest judgment in Vasanta case in 2022 also. This is yet another observation that was made by Justice Srinivasan. And I also told you that the judgment of Ismail has been noted and affirmed by the Supreme Court in this Vasanta case. Then the last reasoning of Justice Srinivasan is a bit disturbing. He virtually says that the proceedings is in the nature of proceedings in rem. If you look at paragraph number 15 in that judgment, this is what he says. The proceeding in rem is a proceeding instituted against a thing and not against a person. We all know that. A proceeding in rem in a strict sense is one taken directly against the property and has for its object the disposition of the property without reference to the title of the individual claimants. But in a larger and more general sense, the term proceeding in rem is applied to actions between parties where the direct object is to reach and dispose the property owed by them or of some interest therein. If this definition is applied, this suit will undoubtedly be a suit for land. Indirectly, he is saying it's a remedy in rem. After reading this, I found that this judgment was the one which started the actual confusion in the Madras High Court. This is where the confusion started. And the learned judge has virtually equated a suit for specific performance where an ancillary relief of possession is sought for with a suit for possession itself. He clubbed the relief of possession and the suit for possession together. Then the next thing is that a few years later, the division bench containing Justice Shivraj Patil and Justice Karpa Vinayagam, this is a judgment in Dhanalakshmi versus Ekanathan. Dhanalakshmi versus Ekanathan was a judgment which was authored by Justice Shivraj Patil. There, again they dealt with the suit for specific performance and for a permanent injunction. It's a suit for specific performance and permanent injunction, and there the judgment of Justice Srinivasan was brought to the notice of the division bench. See how all the pattern is going to change from here. There they hold that looking to the relief sought for in the plaint, this is what they say. It is plain that principally the suit is for specific performance of the agreement and alternatively for the relief of refund of money. Even the ancillary relief of permanent injunction is also for restraining the defendants from alienating or dealing with the suit property in any way. In other words, the suit is not for title or possession. The ancillary relief of injunction sought did not affect the title or possession. The relief sought for are against the defendants in personam. In this view, it is not possible to hold that the suit filed by the plaintiff is for land, even having regard to the decision cited by the learned counsel for the defendants. So, please understand that that was a suit for specific performance and for permanent injunction. And they said that insofar as the relief of permanent injunction, it's an ancillary relief. That will not decide the main object. I said what you should look at the main object of the suit. What is the suit filed for? Then their notice is brought to the judgment of Justice Srinivasan. They deal it like this. In the light of the decision of the federal court, I refer to the federal court judgment, and the full bench judgment of this court, it cannot be said that a suit for specific performance of an agreement in respect of a land can be said to be a suit for land. In this view, the decision of the learned single judge, that is the judgment of Justice Srinivasan, does not help the defendants, and it should be taken as only governing the facts of that case. Sometimes we adopt this indirect method of shunning some judgments. We will say not applicable to this case. So this is what they say. In our view, it is not an authority to say that the suit for specific performance of an agreement relating to land is a suit for land coming within the ambit of clause 12 of the letters patent. Is this definite finding given by the division bench. So they have perfectly applied what I called you as the primary or the direct purpose test. That test they have applied. Then the judgment of Justice M. Srinivasan comes up before the division bench, where again Justice Shivraj Patil was sitting. That judgment also comes before, then the division bench affirms the judgment of Srinivasan. In the earlier judgment of the division bench, they said that it will not apply, it is on the facts of that case. Then when the judgment of Justice Srinivasan is taken on appeal, it comes up before the bench headed by Justice Shivraj Patil. He holds this now. Sometimes when we are very reverent to a person, we lose reasoning, and probably that is what has happened in this case. He says in paragraph number 22 of the judgment, applying the ratio of this judgment, it follows that fourth defendant in the case on hand has to convey title over the suit property to the plaintiff in the event the plaintiff succeeds. This observation itself may not be right, because I said that fourth defendant got possession of the property as a lispendence purchaser. Then it means his title over the property would be affected. Added to this, he has to deliver possession of the suit properties also. Under the circumstances, as rightly held by the learned single judge, the present suit involves title to property, because fourth defendant has got title vested in him, and that is sought to be disturbed by the plaintiff on the basis of the earlier contract between him and the first defendant. Hence, we hold that the present suit is for land. So this is confounding the confusion. It adds up to the confusion now. So basically what Hon'ble Justice Srinivasan, the order which was affirmed by the division bench authored by Justice Shivraj Patil, says is that even insofar as lispendence purchaser is concerned, it will convert that suit into one of a suit for land. So that's what comes out of this division bench judgment. Then this continued for some time in Dhanasekar case. If you are interested, just write the citation 2002 4 CTC page 653. Again it continued in Subba Reddy case 2008 4 CTC page 160. So this position, this trajectory was continuously followed, and the next major confusion came from the judgment of Justice Ramanathan. That was a judgment in Eurotherm case 2014 5 CTC page 41. The confusion was confounded because it was a suit for specific performance simpliciter, where Justice Ramanathan holds that that is also a suit for land, since ultimately when the decree is passed and execution is made, possession comes. Therefore, he says it's a suit for land. So basically this judgment of Justice Ramanathan even goes against that Adcon judgment. Adcon judgment definitely said that if it is a suit for specific performance simpliciter, then it is not a suit for land. The confusion in Adcon judgment is about the observations that were made. But this judgment went even against the judgment of the Supreme Court in Adcon itself. So this was the further confusion which was caused by this particular judgment. And the learned judge goes on to say that after the coming into force of the 1963 Act, Specific Reliefs Act, and the coming into force of section 22 and 28, lot of things have changed, is what he is saying. If that is so, Supreme Court in Vasanta case in 2022 would have said so. Supreme Court didn't say that. They again and again say that it's directory in nature. So not a big change has happened, and as I told you, the various occasions where this will happen. So I will, by ending it, I will give you some illustrations and you will understand clearly as to what I have said now. Then at paragraph number 46, there is yet another finding of the learned single judge, where he says that agreement of sale amounts to interest over the property, is the next observation to justify that it is a suit for land. He says agreement of sale amounts to an interest of the property. Since Suraj Lam's case, everybody knows. Suraj Lam's case, 2012, 1 ACC, page 656, they say that it does not create any interest of the property. The best that you get out of is to convert a sale agreement ultimately into a sale deed when you succeed in that suit. That's the only right you get. But this observation is made in paragraph number 46 in that judgment. Then what happened was, this judgment of Justice Ramanathan was followed subsequently. That happened in Ratan Singh case, 2014, 4 CTC 735, and followed by these 3 division bench judgments. One is the Harsha Estates, where I was the author of the judgment. Then Parandaman's case, 2019, 3 CTC 228, they merely followed Harsha Estates case. Then Shailendra Kumar case, that is 2020, 6 CTC, page 145. Today, the position is that confusing. So today, if you were to get into this, what all comes out? A suit for specific performance simpliciter can today be considered as a suit for land. A suit for specific performance of possession, where you also ask for a possession, but the person in possession is a pendent late purchaser, even then it's a suit for land. Then suit for specific performance, where the ancillary prayer is for a permanent injunction, that will also be a suit for land. These judgments virtually mounted and brought a situation to this effect. Now, if you had carefully listened to whatever I said, I will refer to some illustrations, then you will understand what I am attempting to end with. A enters into an agreement of sale to convey his property to B, right? B did not know that A had sold the property to C. He did not know that. B files a suit for specific performance as against A, and after coming to know that the property has already been sold by A to C, C is also added as a party, and he seeks for the relief of specific performance and for possession of the property, right? Please understand, here is a case where A is entering into an agreement, and by the time he institutes the suit, A had sold the property to C, and B files a suit for specific performance, and he also seeks for possession by adding C as a party into the suit. In such a suit, C is a necessary party. He is not a lispendence purchaser, and by virtue of section 22(2), in the absence of a prayer for possession, you will not be able to get that relief. You understand that difference? You will not be able to get that relief. So C has to be necessarily made as a party. You will have to necessarily seek for that relief under section 22. Therefore, it becomes a suit for land. Therefore, it becomes a suit for land. I will slightly twist this or modify this illustration. Let's take a case where A enters into an agreement to convey the property to B, and the suit was filed. Thereafter, A had sold the property to C. Here C is the pendant delayed purchaser, right? Now, the settled law is that a pendant delayed purchaser can never claim to be a bona fide purchaser. The bona fideness will never come into play in a case of a pendant delayed purchaser, and the relief that is available under section 19(1)(b) will not apply to him, right? Here, if you add C as a party and you also seek for a possession, then that relief is ancillary. That relief is not the main relief you are seeking, therefore it is not a suit for land. It is not a suit for land. So, there are two cases which I said, and the third case is a simple case of A enters into an agreement of sale with B, B files a suit for specific performance simpliciter. That is again not a suit for land. So, my conclusions are: 1, a suit for specific performance is an action in personam. The decree is addressed to the defendant, and the leave under clause 12 can be granted in cases where the property is situated outside the territorial jurisdiction, provided that defendant is within the limits of the original side of the High Court. So, that is number 1. That comes out of all these judgments. 2, a suit for specific performance involving an agreement requiring the vendor to hand over possession to the purchaser does not alter the character of the suit from one of a suit for specific performance to a suit for title or possession. It is a consequence. If you read Order 21, Rule 32(5), you will find that it is a very peculiar provision which many are not. I had an occasion to go through that Order 21, Rule 35. It is specifically for this only. So, even if you have not sought for the relief of possession and you had merely filed a suit simpliciter for specific performance, it can end up with the possession by merely filing an Order 21, Rule 32(5) execution petition before the court, and you cannot say that since you did not ask for a possession in the main suit, you cannot get it. That is something which is not available. That is number 2. Number 3 is the fact that an ancillary prayer is made for possession or for injunction does not really alter the character of the suit into one of suit for land. So, the test of the primary purpose test of a suit as a whole must be seen and not the individual prayers. So, therefore, the first prayer is the suit for specific performance or relief of specific performance. The next prayers by itself will not decide whether it is a suit for land just because you are claiming for possession or you are claiming for an injunction. It all depends. If that possession is sought for where the person has purchased the property even before the suit was filed, then it becomes mandatory because you will have to seek for it because he has got an independent right today and he can always raise the claim of a bona fide purchaser under section 19. Same is the case where a portion of the property is sold, you will have to seek for a partition and possession, then it becomes a suit for land. And therefore, my conclusion is that just because you are seeking for the relief of possession or the relief of injunction, per se it will not become a suit for land if it is seen that it is an ancillary relief and that is not the main relief that has been sought for in the suit. And the object of or the effect of section 22(2), as I said in Vasanta judgment, they have said that it is directory in nature and it is not mandatory. And there is no requirement to actually seek for the relief of possession in case of a pendant delayed purchaser. It is not at all necessary because he is bound by the final judgment in the case. So, my conclusion is that the judgment of Justice N.A.V.J., the one authored by him in this Harsha Estates case, particularly clause 6(b) B and clause 6D definitely requires a reconsideration, and if he had not been so over enthusiastic to write this judgment and he had properly gone through all these judgments, probably he would have come up with a correct judgment, but it's not too late. It requires reconsideration. So I thought I have to, this is something which I wanted to tell to you, to all of you, because you must have the courage to go and accept that you have committed a mistake. You cannot commit a mistake and try to justify it, try to push it down the rags. You should not be doing all those things. If you have committed a mistake, and if you go and say that I have committed a mistake or this requires some reconsideration, people actually will appreciate you rather than looking down upon you. So thank you so much for the opportunity.
I want to congratulate you, Judge. It is very rare to see such an exercise in humility, where a judge on his own accord says, I may have made a mistake years back, and is open and candid about it. I want to congratulate you. There are 2 or 3 other points I want to mention. One is that when I was sitting here, this seemed to take the character of a Truth and Reconciliation Commission. I was also reminded by what all our great sages have said, that the most dangerous thing is possession. But I must tell you, in that particular case, my side didn't go to the Supreme Court because they were okay with going to the court in Tiruvallur where they were sent. They had a relief of injunction in their favor, which the Supreme Court knocked out in an appeal by the other side, because they said if the court has no jurisdiction, how did it give you injunction? But that case has persisted in that lower court with petitions for rejection of plaint and then coming in CRP. It is now in the Supreme Court. I am hoping you get there earliest, Judge, so that we can sort this out well. It has been an absolutely absorbing session, but to young friends, let me add something. I remember that case well. You see, sometimes you're so convinced about the correctness of your argument. I even remember that I labeled a particular judgment as per incurium in that case, because I was so convinced about the strength of my argument. But you must always, I think, be a little careful, because if on the other side there is a very strong-minded and activist judge, then it is wiser not to stand so convinced, but to let the water flow a bit and then try and turn it around. So it's been an absolute pleasure, and it's so nice to see such a wonderful, such large numbers, but since it's for Justice Anand Venkatesh, I'm not surprised.
May I now request our Secretary to give the vote of thanks.
My Lord, Justice Anand Venkatesh, he needs a big
Good evening to everyone. This topic, judge criticizing his own judgment, really attracted me to this session. Judge should be very, very bold to say about his own judgment in a very critical manner. This reminds me of the year 1980 when I joined the profession. All of you must be knowing Justice Krishna Iyer, Dian of Supreme Court, one of the finest judges. According to Mr. Nariman, is the Everest of the judges. There was a seminar in Kanimara Hotel, in respect of his 6 or 7 landmark judgments, which are even now hold the field. Justice Mr. M.R. Narayan critically analyzing his judgments, and Mr. Dolia supporting his judgment in the presence of Mr. Justice Krishnaiyer. I don't recollect what exactly Krishnaiyer said after the conclusion session. After that seminar in 1980, in 2024, I come across a much bolder session of this type. This session is really rewarding. Thank you so much, sir.
Before I start, I request everyone to give a big round of applause for his courage, intention, and desire to set right the correct proposition of law. So that should be the attitude of a judge. A judge, they're all human. To err is human. It's very, anybody can commit. But his intent to set right needs very larger heart. And we really appreciate him a lot for your thing. And he's a very erudite person. Everybody knows. He's a very erudite and is known for his writing very fantastic judgments appreciated by one and all. And now he has got a fan club. Once you just open the YouTube, many of the YouTube things are from His Lordship Anand Venkatesh, and all youngsters, students have say, oh, you know, that judge spoke this way. Your judge said, I can also one day become a great man, I'll make a lot of money, but now I'm not making money. So no work and I'll make more money. All these words, everything they learned from His Lordship's thing. So even I am personally affected by Lordship judgment because many of the High Court lawyers have lost the brief because if everything is considered to be a suit for land, we have to go to the district court or the subordinate courts. And the second irony is, now at least, okay, 3%. Now earlier it was 7.5% court fees. So we have to pay the 7.5% court fees. So all these things, we all really face a lot of difficulties, but a Lordship has realized that difficulties we will overcome that, and the lawyers will have a heyday shortly. So with all personal difficulty, but the larger heart to accept that needs a lot of courage and attitude. We thank. And I thank Additional Solicitor General, who has graciously also acted as a president for the time being, because the president had to. He has got a family marriage, so he has to go to Coimbatore. Suddenly he left. I thank ASG sir for your gracious thing. And I thank the president of Madras High Court Advocate Association, Mona Krishnan, the secretary, and Louis Saul, president of WLA, and the secretary, and NR Ilango. We have to thank NR Ilango, Madam Ilango, and daughter for such a gracious and the kind of an act, what they have done it for bringing intellect to the students and other community. Really, it is the greatest act and gesture. Because so much of people, youngsters have come and they have just enjoyed thoroughly this lecture. But for their gesture and act, it wouldn't have happened. Thank you very much, sir. Every year we will continue this. And His Lordship has also agreed that every year he will come and again give a lecture. Thank you very much, sir. And I thank Justice Subramaniam, is a fond MBA member. So, and Justice Kumarappan is here. Sorry, Saktivel is here, and senior advocates and additional advocate General Manoharan, and Neelagandan, and the dawn of the bar, and the mediation is here because of you, sir. We need a great appreciation for that. And all senior advocates and all other friends. And especially I requested some of the people to come and sing the Tamil Thai Varthu. Immediately the Women Lawyer Association persons have accepted and just they came and participated. And our owner is here. Oh, sorry, I'm our president of the past president, Kamal Nathan. He has done a lot of things for the Madras Bar Association. It's a big appreciation. And also the persons who have done this live relay of this program, and our staff, and Shiva Shanmugam, who has coordinated well for this program, for the meticulous organization, Satish, and all other members. I thank you one and all for this program, and I request all of you to attend more such programs whenever it's conducted by the MBA or other connection with coordination with other people. Thank you all. Thank you very much.
National anthems.
National anthem.